Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, the Florida Bar has said that I have to give you a legal disclaimer. So here it goes. This podcast is not legal advice, but nothing is ever going to prevent me from giving you an easy to understand overview of the disability insurance world, the games the disability carriers play, and what you need to know to get your disability benefits. So off we go. Today, I'm going to talk about the full and fair review requirement and how courts interpret the carrier's statutory obligation to you. First, I'm going to talk about what does a full and fair review mean to a denied ERISA disability policyholder or beneficiary. Secondly, I'm going to talk about second time around on a disability claim and how one federal judge threw the book at a disability benefit claim administrator who missed deadlines, edited and changed their doctor's reports, and failed to produce requested plan documents. And lastly, I'm going to talk about why you've got to exhaust your administrative remedies by filing appeals in your claim and why you just can't blow up your case and send it right to federal court without filing an appeal. So let's take a break before we get started with this week's episode. Welcome back to Winning Isn't Easy. I'm going to talk about why you have to exhaust your administrative remedies by filing an appeal in your disability claim and why you just can't blow up your case and go right to federal court without passing go. The Employee Retirement Income Security Act, ERISA, requires that a denied disability policyholder or beneficiary file an appeal of the denial and do so on a timely basis. If you don't file the appeal or you don't file it timely, you are going to lose. And it's as simple as that. But let me explain. In the case of Tice versus AT&T Corporation, Tice was paid short-term disability benefits. Her claim was then denied. The plan had a 2-level appeal process, and Tice did not file the second-level appeal. So when she filed a lawsuit, the disability plan said, hey, she hasn't exhausted her administrative remedies, Judge. Dismiss this claim. And the judge said, you're right. Tice had made 2 mistakes. First, she didn't exhaust her administrative remedies by filing the second-level appeal. And secondly, she didn't file her lawsuit within the time frame provided in the plan. So either mistake 1 or mistake 2 were fatal to her claim. And the judge upheld the denial of the claim. And this is a reason why a denied policyholder really needs the help of an experienced ERISA disability attorney. The appeal must be filed timely. It's the trial of your case. Nothing new can be added once the appeal period has run. So you can really make 3 mistakes: not exhaust your remedy, not file the appeal, and just basically ignore the whole claims process, which is central to the ERISA claims process. And what will happen is, regardless of how legitimate your claim is, the judge will dismiss this on what appears to you to be a technical basis, but which is really an important component of the ERISA disability appeals process, fair or not. So you need the help of an experienced ERISA disability attorney timely if your claim has been denied. Otherwise, you've just killed your case. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, consider liking our page, leaving a review, or sharing it with your friends and family. Also, why don't you subscribe to this podcast? That way you're going to be notified each time one of these great new episodes comes out. I hope you tune in to next week for another insightful and exciting episode of Winning Isn't Easy. Thanks.